from social media platforms to e-commerce websites to healthcare providers to government agencies, we do realize that our data is collected and sometimes analyzed or processed without our consent or awareness. And as we go into the discussion today, I'll just share my screen and share the slides with you. This will be our presentation outline for our discussion today. We shall look at the legal and regulatory framework of data privacy and protection in Uganda. Then we shall also look at the complaints handling procedure and then delve into the benefits of effective complaints handling in our organizations. We shall then look at the ethical considerations while handling these complaints and finally have the question and answer session. But before I go into today's topic, I think it is relevant for us to have a brief background on establishment of the Personal Data Protection Office, or what many know as PDPO. A person's right to privacy.
Sorry, maybe before you go further, we are not able to see your presentation.
Okay. Just a minute, let me just... Please confirm that you're able to see it now.
Yes, we can.
Okay, thank you so much. So as I was saying that the person's right to privacy is protected under Article 27 of the 1995 Constitution of Uganda. And that's where this right is enshrined. However, it is relevant for us to note that it is subject to certain limitations, and these limitations should be within the constraints of the law. We then had the enactment of NITA-U Act in 2009, and it's with the responsibility of regulating data protection and privacy in Uganda. NITA-U Act that provides for the National Information Technology Authority of Uganda. And in 2019, we had the president assenting to the Data Protection and Privacy Act. And this was as a result of data protection and privacy being a global phenomenon, having evolved across various countries. As Uganda, it was prudent for us to also have the Data Protection and Privacy Act in place to be in position to regulate the privacy and protect the right to privacy as enshrined in Article 27 of the Constitution. Then in 2021, we had the regulations which were developed and gazetted by the Ministry of the ICT and National Guidance. And then in August of 2021 is when we had PDPO being operationalized as an independent office within NITA Uganda. Now, it is also important for us to note that people tend to confuse PDPO and NITA, but the distinction and difference is in their duties, and NITA is, PDPO is an independent authority within NITA. I think we're all aware of the government's procedure and policy of limiting the number and creation of new agencies and new authorities. Now, because that policy is in place, that's why it was, and yet PDPO as an office was important to be established in Uganda. They thought it wise to have PDPO being put under an existing entity, which is NITA Uganda. And that's why, whereas PDPO is an independent office, it's separate and distinct from NITA Uganda. And the only areas they do share are probably administrative and HR affairs, but NITA is actually regulated by PDPO. So that is the distinction and the background of the establishment of the office of the Personal Data Protection Office. Now, like I earlier stated that the right to privacy is provided for under Article 27 of the 1995 Constitution, but it is impossible to talk about the right to privacy without talking about the right to data protection. Though these rights may be subject to certain limitations, and as you may look at Section 7 of the Data Protection and Privacy Act, it provides for some of those exceptions under which this right might be limited. Issues to do with national security, or for medical purposes, or for proper performance of a public duty by a public body. Under such circumstances, we may see certain limitations to the right to privacy. When we further look at Section 10 of the Data Protection and Privacy Act 2019, it mandates all data collectors, data controllers, and data processors to protect the right to privacy. And one might ask, who are these data collectors and data controllers and data processors? As the words state themselves, data collectors are those organizations that do collect people's personal data. And it should be important to note that here we are dealing with personal data. And personal data is that information that can identify you as a person, starting from probably your name or your national identification number, your photograph. That is what amounts to personal data, and that is what this office regulates. When you further look at Section 31 of the Data Protection and Privacy Act, it provides data subjects with the right to raise complaints to the authority being PDPO in this case, in relation to violation or infringement of their personal data. However, before raising these complaints to PDPO, we always encourage organizations to manage them at that level before raising these complaints and them escalating to the regulator. And Regulation 40 emphasizes that, Regulation 40 of the Data Protection and Privacy Regulations, I think Anita also earlier talked about it, which provides for a complaints handling system to be developed and implemented by data collectors, controllers, and processors. And this is basically to help with handling complaints within the organization. Then when you look at our website, we've also drafted guidance notes on lodging complaints with PDPO, and this was done in 2021. So some of these guidance notes provide for certain criteria under which data subjects can actually lodge complaints with the authority. If we are to proceed further to understanding data privacy complaints, like I earlier stated, that the Act, the Data Protection and Privacy Act in this case, imposes obligations on persons, institutions, and public bodies, collectively referred to as organizations, on how they should handle an individual's personal data. And handling of personal data means to collect, to use, to disclose, to erase or destroy personal data. As an organization, once you're erasing personal data of probably the subjects such whose data you collect, how do you do it? Do you just tear papers and probably throw them where someone can easily patch them up and know exactly what information to pick out of there? Or do you probably shred them? So those are some of the ways under which amount to handling of personal data and which are regulated also by this act. And a data privacy complaint is any dissatisfaction with the way the personal data of a data subject is handled. So as organizations, we have that obligation to handle personal data of the data subjects within the constraints of the law. That is why today we find it important for us to look at these complaints and what types of complaints are there and how you can handle them as an organization, because you should be in position to encourage data subjects to handle before they run to social media, for example, or before they run to authority. They should be in position to address these issues with the organization. Now, the types of data privacy complaints that we shall be looking at under these circumstances. One includes the unauthorized access to personal data. As organizations, there are circumstances under which certain organizations unlawfully access people's personal data. For example, I'm sure many people on this webinar today have attended conferences or entered certain premises where they are required to provide their names and their telephone contacts. But do you ever go back to ask yourself how this data is collected or how it is kept and stored? Because this is an area that certain people use to abuse this right to privacy, because there are certain circumstances under which, for example, I have found myself receiving messages from organizations that I'm not aware of, and I kept asking myself why they actually have my contact and how they do have it. So one of the complaints that can be raised by data subjects is unauthorized access to personal data. The other is failure to declare information about a data subject. This is a right that data subjects have, and as a matter of fact, they are entitled to have access to information that you have about them as an organization. And in circumstances where this information is inaccurate or incomplete, they have that right of rectification. This information should be rectified and updated. So when a data subject comes to you as an organization and is probably asking for the information that you have about them, you should not shy away from declaring this information. Otherwise, it will amount to a data privacy complaint. And that is something that could probably affect the reputation of the organization. Then the other is sharing of personal data of the data subject without their legal consent. And this is in circumstances whereby, consent is at the center of data protection and privacy, as provided under Section 7 of the Data Protection and Privacy Act. Data subjects must consent to processing and collection of their personal data. And in circumstances where this data is probably collected and shared without their consent, I mean, you may find that your organizations that deal in the same space, so you probably decide to share certain contacts because you're looking at increasing the number of customers. But I mean, do have the data subjects consented to that sharing of the data? So that is an aspect that you need to look out for as organizations when it comes to data privacy complaints. The other is misuse of personal data, such as for direct marketing without consent. And for those that might not be aware, there was a case a few years ago of Shadia Nalubega versus Starbucks, where this lady was an employee of this organization, but at a certain point, she left the organization, and the organization had pictures of her, and they're using these pictures for marketing of their products. And this was being done without her consent, okay? So the court came out to state that no, for any data subject, if you probably want to use their pictures or their photos for direct marketing or for any other reason, there must be consent of the data subject. And in that circumstance, the organization, which is Starbucks in this case, was actually held accountable for breach of data privacy. So if you look at now the complaints handling procedure that we are interested in looking at today, this is a procedure that it's a management procedure which describes the steps to resolve complaints from data subjects arising out of misuse and processing of personal data. And it is important to note that this tool enables easy coordination and monitoring and resolution of complaints within the organization before these complaints actually escalate, because it is always better as an organization to deal with these complaints internally without them getting out there in the public eye, because that could come at a very high cost, especially to the reputation of the organization and other factors that we shall look at later on in the presentation today. And now we are going to proceed to the steps of handling these data privacy complaints. When you have these complaints, how do you handle them as an organization? And quick to note is that when you're registering with PDPO, one of the very first things that we ask of you as the requirements is information details of a data protection officer. Now, we found out that quite many of these data protection officers may actually not be aware of their roles, but one of their roles actually is to handle such complaints of data privacy that may arise. And as an organization, we've taken it upon ourselves to create awareness and trainings like this, under which these DPOs, like we know them, are trained on their roles and what they should be able to do. Because, I mean, we are requesting them and asking them, you do realize that data protection is a new field that is not known to everyone. That's why there's need to create that awareness and of the data protection officers. But now when you appoint the data protection officer, that does not amount to compliance, or that doesn't, it's not just a box that you tick. There's need to groom them, and when that process starts with the appointment of the data protection officer, they should know their role also constitutes handling data privacy complaints. The other step that you need to take as an organization is indication of the available channels of communication of data privacy complaints. And we require these organizations like yours to have privacy notices where customers or data subjects can be in position to you avail the information, probably an email or telephone contacts or online links that data subjects can use to file their complaints with the organization. When you create these channels, and it's also important to state probably what working hours you receive these complaints. If they can maybe have walk-in sessions, that could also be fine. So indicate probably on the website of the organization how you handle these data privacy complaints when they arise. The other is prompt acknowledgement of data privacy complaints. Certain organizations are very quick to rush to the defensive and try to bash the complaints of these data subjects, but it is always prudent for you to acknowledge the complaint and then go ahead and assess the nature of the complaint. Is it a complaint that amounts to breach of personal data or of the right to privacy? You need to be in position to assess the nature and know what steps to actually take on, because it could be any other complaint, but like we're dealing specifically today, it's with data privacy complaints. They should be on infringement of one's personal data. Then the other is communicating the timeframes for handling the complaints. It doesn't end at just you acknowledging the complaint and you creating these channels, because I mean, as organizations, you could create channels, but then it could end at that. But take it upon yourselves to actually communicate timeframes under which you handle these complaints. And according to the guidance notes that we have at PDPO, we give data subjects a time frame of 30 days within which you should be able to solve their complaint as an organization. So in those 30 days, in case they're dissatisfied, because before they actually get to us, we always inquire if they have addressed this issue with the organization. So that time frame of 30 days, we feel is enough as an organization to do whatever it takes to probably resolve or take the steps towards resolving a data privacy complaint. And after those 30 days is when they can now come to the authority. So there's need to create timeframes, probably give them, let's say this complaint will be handled within a period of, let's say 2 weeks or of 1 month. They should be in position to, there is need for that communication, because I mean, it shows that this complaint is being worked on and builds some sort of trust and loyalty from the data subjects. The other is conducting thorough investigations and interviewing the concerned parties. When you receive these complaints, there is need for you to conduct interviews of probably the parties that are involved. If it is an officer of the organization, if it is the complainant themselves, or in case there are probably witnesses, there is need to have those investigations and collection of evidence that you can use while handling these complaints. You, as organizations, I know some might probably, like already stated, that they might want to go on the defensive, but before you get there, there's need to actually ascertain the true nature of these complaints, because that's what Equity really asks for. Then the other is documentation and tracking of these complaints. There's need to have probably create maybe Excel sheets where you can follow up on the track and the progress of these complaints. If you've probably now had, like I talked about these steps, you've probably had interviews or you've had investigations going on, what are the findings? This is documentation you will need to keep track and progress of these complaints. And as a matter of fact, you also encourage data subjects to be in position to lodge these complaints formally. For example, they could write to you an email or a letter, or if it is telephone contacts, but usually we prefer having that evidence documented so that there is that follow-up in case of future references. Then the other is resolution and communication of the findings of the complainant. So when you do make a resolution as an organization, there is need for you to communicate this resolution to the data subject, the complainant, because, for example, especially, I'll also want to state that when making these resolutions, it's important for you not to probably involve the concerned party from your organization as part of the people who are making the decision on the resolution that is to be made on that particular complaint, because that also breaches the principles of equity that we shall probably also look at later on in the discussion. So there's need for you to communicate that resolution to the complainant, and also reviewing and improving the complaints handling system. As PDPO, we've also tried so much to ease compliance with the Data Protection and Privacy Act. And one of the ways we've done this is also through creating guidelines and guidance notes that you can always refer to in case of in case there's need to look at some of these templates probably. So if you look at Form 11 of the regulations, it will give you a standardized form for complaints, especially on data privacy. So as an organization, you could probably work away and be in position to customize it to the needs of your organization. You should be in position to bring out what, probably if you're going to interview a complainant, what are some of the aspects you should be looking out for, what are some of the issues you should be looking out for. That form will help you as organizations, and this is accessible on our website, where you can download it and always customize it to the needs of your organization. Lastly is training staff on data protection and how to handle these complaints. Because yes, you might have all these things in place, but you probably don't have the staff. The staff are not equipped with the knowledge in terms of data protection. And like I already said, that this is an emerging field. So there's need to probably create this awareness and create this training of your staff. As PDPO, we always do encourage organizations to reach out in case they need to have these trainings, because one of the functions of PDPO is to actually create awareness of this act and not just implement it, but also create the awareness. So you can always have training sessions with your organizations on how to ensure compliance with the act, because I mean, non-compliance also comes at a cost. So there's need to have these training sessions, and in case of such trainings that you might need as an organization, you can always reach out on info@pdpo.go.ug and you'll always be helped. Then we shall further look at the benefits of effective complaints handling. What is the need? Why do you as an organization need to comply with effective complaints handling? One, like I already said, is the reputation of your organization. I don't think there is any organization that wants to be out there in the media known for breaching data privacy. That, you know what, this particular organization, once you share your personal data with them, you could probably find it somewhere in the media. And you know, these days, somehow, you do realize that every letter that the president, His Excellency, writes somehow ends up in media, and you ask yourself, how is this actually happening? So you don't want to be the kind of organization that is known for, you know, putting people's information out there. So that's why there's need to have a complaints handling system to enable you handle these complaints without them reaching that stage, because it will probably also affect the reputation of the organization. The other is customer satisfaction. And I'm sure that, for example, if you are the complainant and you complained to an organization and indeed got actually worked on, that will create some sort of satisfaction that, oh yes, when I do complain to this organization, it will not just be a matter of me complaining and they do nothing about it, but they'll actually take steps to resolve it. So there's need to have that customer satisfaction. As an organization, it will come a long way in ensuring the progress of the organization. Then the other is that it also demonstrates compliance with the Data Protection Act and regulations. And compliance is a very big issue, because you do realize that as organizations, there's probably very many acts and regulations that you need to comply to. So at times it becomes a burden. But when you do handle some of these issues before them escalating, when you do have effective handling of these data privacy complaints, it will also demonstrate compliance with the act, because at the end of the day, you know that you're required to always file annual compliance reports to PDPO as organizations. And in these compliance reports, you can always state probably the number of data complaints that you've been able to handle and how you actually probably resolve them. So that also goes a long way in ensuring and demonstrating compliance with the act. The other is better risk management and quality assurance, because as organizations, when such incidents happen, along the way, you do realize probably the loopholes that you need to address as an entity, which will in a long way ensure quality assurance and enable you to minimize on the risks, because data protection goes to the root of the organization. It is a top management decision that should be enforced by the organization, because if at all the reputation of the organization is affected because of issues to do with data protection and privacy, it's going to go a long way in affecting the business or the prosperity of any organization. So that's why when you handle such complaints, it's easy for you as an organization to deal with them better next time, or find better ways of handling these complaints. Then the last one is avoidance of penalties. And you do realize that according to the Act, certain penalties arise as a result of non-compliance with the Act. So issues to deal with data privacy and data protection do attract penalties where there is breach. So as organizations, I don't think you would want to be in the business of paying penalties because you fail to protect the personal data of the data subjects. So you, as an organization, there is need for you to handle some of these complaints even before they get to that level. That's why we are pushing for effective handling of such complaints. Then we shall also look at the ethical considerations while handling these complaints. What do you base on? There is need to have fairness and equity. Avoid being biased and defensive while handling these complaints. You shouldn't probably just say, no, this is something that, that you can easily write off. There is need for you to be fair, not only to your organization, but also to the data subjects, because it is that balance of fairness that will create or will lead to a better resolution of these complaints. Because at the end of the day, when, for example, if this complaint is not resolved effectively, what will happen eventually is that these data subjects actually do have the rights to appeal your decision to the authority. So they can always appeal and come to the authority. And as an organization, I don't think you'd really be in the business of being caught on the wrong side of the law. So that's why there's need to always create that fairness and equity. And like I earlier stated that, for example, if there's a concerned party who is involved in this in this complaint from your organization, they shouldn't be the ones actually being the judge in their own case. That's why there's need to have that fairness and equity. The other is confidentiality and integrity. For example, you don't want to be handling an issue and also putting it out there in the media. Yeah, there's need to have that confidentiality. There's need to have that integrity as an organization, because it will build trust for your organization and also create that customer satisfaction that you're probably looking out for. So those aspects also need to be interplayed while dealing with these such such data privacy complaints. The other is transparency and independence, and this is a bit connected to the fairness and equity that I talked about, because there is need to have and show that transparency in the system, because if a data subject knows that, or a complainant knows that your system of handling such complaints is probably is not as straight, they will not actually even be interested in coming to you, because they'll know it is probably, you know, a waste of time. So you need to be in a position where you're able to build these robust systems that are independent and are not affected by any bias. And usually, actually, we do encourage organizations to also, on top of having a data protection officer, you could also have a committee for data protection. And these are people from within the organization that can always meet on a regular basis to handle such complaints. Yeah. So in circumstances, for example, where a member of the committee is also the one involved in the case or the complaint, they can always excuse themselves out of handling such a complaint. So that's why they need to have that transparency and independence while dealing with these complaints. The other is communication on the progress of the complaints handling system. Like I said, that communication is key in any relationship, be it with the organization or with any other parties. So they need to have that regular communication, probably if you're done with the investigations, or if you're done with collection of the evidence, or if you have resolved the issue, they need to have that communication, other than taking on a complaint and then, you know, keeping quiet. At the end of the day, it does not solve the problem. And yet what we're looking out for here is to effectively handle this complaint without it actually reaching the authority. So there's need to have that communication on a regular basis on how far you've gone with the complaint. Then there's also need to be accountable, because accountability is also one of the principles of data protection. So as an organization, if you do find yourself in a position where, for example, you indeed breached the privacy of the complainant, there's need to be accountable and take on the role of, you know, saying, yes, we did this and this, and probably find ways of resolving it with the complainant, other than being on the defensive always. Because for some organizations, I'll probably not those that are here today, but for some organizations, they always think they are on the right side of the law. They're always the right ones, and the complainants are the wrong ones. So there's need to have that accountability and have that transparency and the fairness and the communication while handling these complaints, if we are to do that effectively. And at this juncture, I think we shall end our webinar today with any questions that may come from the audience. Thank you so much, Anita. Back to you.
Thank you so much, Jordan. That was a very, very insightful presentation. And I want to believe everyone has been able to learn a thing or two on the complaint handling process. We are going to move straight to the Q&A. If you have any questions, please feel free to type them in the Q&A section. Jordan, are you able to see the Q&A? I'm going to be reading for you, I think, like 2 questions at once, if that is okay with you.
Yes, that's fine.
Okay. So someone asked, is a deletion request for personal data considered a complaint? That is question 1. And then the second question is, how about if the data subject is the one responsible for the inaccurate data provided and they request collection? Is that viewed as a complaint as well? You could maybe take those 2 and then we'll go to the other questions.
Okay, thank you so much. I think I'll beg your pardon on the first question.
The first question was, is a deletion request for personal data considered a complaint?
Okay, so thank you so much. For deletion, you do realize that according to the Act, these data subjects have the right to erasure, a right to be forgotten. So if they do request for their data that you do hold to be erased, I think that is not a complaint, but rather it is in their the performance of their right as a data subject, because they're entitled to this deletion of the data. But of course, there are always those exceptions, like I always said in the Act. If it's a matter of national security, or if it's a matter of the law. For example, you may not go to NERA and say, you know what, you have my data, I need you to delete it, because they have that mandate by the law to collect this data. So I don't think that would amount to a complaint, but rather it's a right that these subjects are entitled to. Then the second question was on how about if the data subject is the one in wrong? Did I get that right?
If the data subject is the one responsible for the inaccurate data provided and they request collection, is that viewed as a complaint?
I do not think that is a complaint, because if they are the ones that submitted this inaccurate data, it will now be upon you as an organization to probably request for rectification of this data. But if they're the ones actually asking for, if they probably submitted inaccurate data and they're asking for its rectification, that is within the ambits of the law as a right that they do have to correction of the data that you do hold. Thank you, Anita.
Okay, thank you very much, Jordan. There's a question on, please talk about the right to withdraw consent and how this may affect business. And another question is about a PDPO training done by PDPO. Okay, are the trainings done by PDPO paid for in case an organization wants to invite you to train staff? I feel that was talked about earlier, but you can speak more to that.
Okay, thank you. I'll start with the last question. The trainings are not paid for. You can know it is within the mandate of the law that we do are supposed to create awareness, and it is upon us as an authority to always train organizations on how probably to handle complaints or any other data protection matters that may arise. Then the other question, Anita, I beg your pardon on that.
Please talk about the right to withdraw consent and how this may affect business.
Okay, the right to withdraw consent. Thank you. Data subjects, yes, do have the right to withdraw consent, and this can be done at probably if you already have their data or you are collecting their data. For example, we do usually advise them to read these privacy notices that you do have on how you collect their data and how you process it and how you probably store it. Yeah. So if a data subject is probably cautious about how you as an organization store your data or process your data, they have that right to withdraw that consent. It is a right that they do have. Over to you, Anita.
Okay, thank you very much. I am seeing a couple of questions people asking whether the slides will be shared. This will be shared with you for further reading. And for questions about the annual compliance report, we will be able to make a communication on that at the end of this session. And then another question to you, Jordan. Someone said, hello, you recommended the Form 11 for referencing data handling systems. However, the Form 11 on the website is for filing a complaint. Please provide guidance on the form that can guide us on complaint handling.
Okay, the Form 11 that I recommended, that is in the regulations, is it states certain specifics that you, as an organization, you need to probably look at while customizing your complaints handling system. So those are areas that you can probably use, like I said, to customize your handling system. For example, if you have a form that these data subjects can fill while raising their complaints, if it's an online link, that's something you can use to customize and be in position to ease receipt of these complaints from the data subjects. That's why I recommended that you can just use an extract of that to formulate these complaints handling forms. Thank you.
Okay, thank you, Jordan. A question related to what you just answered. Someone was asking, what is the validity for the consent?
The validity of the consent. So it's not like it has probably 24 hours or something, but consent will be as long as it's obtained lawfully, it will be valid as and when it is revoked. So in circumstances where the data subject revokes the consent, at that moment is when their right to withdraw consent actually arises, because you cannot say that, for example, they could consent today and tomorrow they probably are not into you collecting their personal data. So there is no sort of time frame, but rather it all depends on when they actually revoke this consent. That is when it ceases to be valid consent. Thank you.
Okay, thank you, Jordan. Another question is, with the introduction of AI and other new technologies, how should institutions handle the misuse of these technologies and data theft, which is mostly done using these technologies?
Okay, thank you so much. So AI is an area that is really booming at the moment, and it is affecting very many organizations and their reputation, even when it comes to compliance with the Act and the laws and the regulations. So there is need to create a careful balance between how organizations can actually use these AI tools, for example, while collecting personal data or while processing it, vis-a-vis the right to privacy and the right to data protection. So whereas it is a concern that we also do realize as PDPO, and then probably an area that we need to focus on as well, given the rising trends of AI, there is need also as organizations to be on the lookout on how best to deal with such tools and how best to ensure compliance within the ambits of the law while handling that. Thank you.
Okay, thank you very much. Okay, there's a question here in the chat. Someone asked, in case a data subject. Okay, the question is not really clear. Anna, you could just retype that question and we'll be able to answer it. Okay, there's a question which is also, I don't know whether he was asking about how to file a complaint, but it has one, how to file a complaint, and then two, common issues leading to complaint. I do not know, Jordan, whether this person wanted to find out the common issues maybe that may lead to data privacy complaints. But I also feel like this is more like the types of complaints that you talked about earlier, but I don't know how you would like to approach that.
Okay, let me try to answer that. I think on how to file a complaint, I think that is really asking on how to file a complaint with the office, because for organizations, like I earlier stated, that there's need to have those channels that you as organizations use to address these complaints as and when they arise. For example, having an email or having a link or having a telephone contact, probably with the data protection officer, that can always be used by the complainants while handling these issues. But when it comes to the authority itself, we have various mechanisms under which you can file your complaints. We have the online platform where you can go to our website and be in position to fill in the details of the complaint, your details as well, and we always reach out for any further information about your complaint. You can as well use our USSD code, that is *260#, and you can always be in position to proceed with the prompts, the instructions are given, and be in position to also lodge your complaint through that mechanism. And that is a free mechanism. Then you also can probably walk in and be in position to be attended to by the officers at PDPO while taking in your complaint. But for the issues leading to some of these complaints, I think that also relates to more of what I talked about earlier, that, some of these entities are not even aware that what they're doing is probably a breach of data privacy. For example, you picking up someone's pictures and using them to market your products. You may not even be aware that you're breaching data privacy, but so for some of them, it is ignorance of the law, but like we already know that cannot be a defense, so you'll still be held liable. And for the others, it's really some organizations just want to be on the defensive, like I already said, that they always want to feel like, no, what they did was actually right. So that leads to such matters being escalated. But yeah, like I stated, that these complaints need to be handled effectively internally within the organization before them actually reaching the authority or even escalating to other social media platforms and whatnot. Thank you, Anita. Back to you.
Okay, thank you so much, Jordan. There's a question about whether it is possible for the office to send notifications of expired registration status through mail, probably a month or week before. We are currently looking into this and will be able to provide feedback once this is done. However, you should be able to know that you're supposed to submit your application 3 months before the expiry of your current registration. So 3 months before your year ends, you should be able to start working on your renewal process. Okay, Jordan, another question to you is, for organizations that host congregations and take photos and videos, what mechanism of consent do you advise to be used as consent by signing?
Okay, so that is an interesting question, because I do believe for many of us that may be churchgoers, you probably find yourself in such situations where your pictures are being, taken. But I think that's an area also we need to look into as an organization, because you going to church does not really amount to you consenting to some of these things or some of these pictures being taken. But I think I've seen, for example, when it comes to concerts, where the organizers usually put up notices of such privacy notices, that probably once you do come to this concert, probably you're comfortable with your pictures being taken. And for some others, especially for like workshops or conferences, I've seen when people actually filling in their details, there's always a column for them to probably tick whether they consent to their pictures being taken during the conference or during the workshop or not. And some actually do not consent to that. So that is an area that we are looking into, that you can probably see how best to regulate as an organization. But yeah, there's need for that consent to be sought while dealing with some of those entities. Thank you.
Okay, thank you so much. One more question. I believe this is going to be probably the last question. Do you think having a separate data consent form is the best way to go, or embedding it in the account opening form is adequate?
Okay, I think having a separate consent form is really a better option, because I mean, for example, when it comes to employees, for example, while you are signing your contract of employment, there's need for you. Just because you've signed a contract does not necessarily mean that you have actually probably consented to your personal data being maybe your pictures being used for publicizing the organization or something like that. That's why there's need to have a separate consent form under which probably the employees or any other data subjects need to fill to indeed show that they've consented to some of these things. So I don't think having it as a blank check would really, as having it as a blank option would really be the best way to do it. Thank you.
Okay, thank you so much, Jordan. I do not see any more questions. I am going to make some communication and then return back to you for the parting shot. So you are required to submit your annual compliance report. And this is between 1st July and 30th September, because as we all know, the financial year is ending on 30th. So please make sure you submit your report. And point to note, we have automated the process at the moment. So you will be logging into your PDPO account, and then you feed in the annual compliance report. At the end, you'll be able to preview what you filled in as well as download it. So please make sure you are able to work on that. The financial year we are talking about is 2023-2024, which ends at the end of this month. I earlier shared the link in the chat. Please click on that link and give us feedback. The feedback you give us enables us to make these trainings better for you. Beyond submitting annual compliance reports, maybe for those of us that are data protection officers here, it is important for us to know that some of our key roles are: one, renewal of registration, and this should be done 3 months before the current expiry. And then notification of data security breaches, which should be immediately you face a data breach in your organization. And then, of course, notifying the office of changes in information on the data protection register. I'm seeing a question about how about those who already filled the report for 2023. Yes, that was actually 2022-2023, and what we need now is for 2023-2024. That's the year that began July 2023 to June 2024. The presentations will be shared on the emails we used to register for this webinar. And if you have any questions regarding registration, please send an email to registration@pdpo.go.ug and you will be responded to. For those saying you submitted a report for 2024, no, we basically look at the financial year. And if we are saying the financial year from July 2023 to June 2024, you cannot have submitted because this year has not yet ended. It ends on June 30th. Okay, I think Jordan, over to you for any starting shot.
Okay, thank you so much. I'd like to thank you all for attending the webinar today. I'm exceedingly humbled for having been invited by PDPO, and we look forward to ensuring that we equip data protection officers and various organizations with various toolkits and compliance mechanisms that they can use to ease their compliance with the Act as well as the regulations, and continue buttressing the right to privacy and data protection as provided for under the Act. Thank you so much, and back to you, Anita.
Yeah, thank you so much, Jordan. Another communication maybe to make on the compliance report. We shall send you an email regarding submission with the details, and also to guide you about the new way of submitting reports, because like I mentioned earlier, we automated the process. If you do not get an email from us by 1st July, kindly reach out. This information will as well be available on all our social media platforms. So feel free to follow us so that you do not miss out on some of these important updates. Thank you very much. Have a wonderful day.